So call the meeting to order. And my name is Gary Merchant, Representative Gary Merchant, the chair of the board. And with me today is
Sorry, Cindy Rosemont, Senate District 13.
Todd Fahey.
Thank you. And also we have assisting us today are Olympus, like to introduce yourself.
Nancy Florence support.
Thank you, Nancy. So I did speak to Senator Sherman. He will be here momentarily. He was in the cafeteria grabbing a quick bite to eat before he got here, so he'd be about a few minutes late. We have a quorum. We have three of us, so it does make a quorum. I will take this moment to elevate Senator Rosenwald from alternate to a permanent or full member, if you will, to satisfy both the quorum and allow her to participate today in the meeting.
Thank you.
In regards to the agenda, is there anything that people want to add to it, change, modify, or at this point in time? All set? We all okay, move on. All right. In your packet is a copy of the minutes from last time. Again, thank you, Ms. Ford, for putting this together for us. I did not see any issues with it. So if we can have a motion on the table to approve the minutes.
So moved.
We have a second, please. Second. And all those in favor say aye.
Aye.
Anybody opposed or abstain? The ayes have it. Move on. In regards to the rule draft, Mr. Barry, if you want to join us, you can kind of go through this with me as well. I did want to say thank you to Allison for putting these together. I believe the changes that she did, I just kept my copy from last time, so we can walk through it. And if you have a copy that's numbered on the side, it'll be helpful. Okay, well, you got good eyesight.
For now.
So we try to, at this point in time, put numbers on the page that are not quite as clean as the OLS would do for us, but I think we'll make the point to at least follow along. So would you like to take us through it, please?
Sure. So the big change to start off with is we now have a prefix. Instead of the XXX, we now have PDAB as our prefix now for our rules. So I made that change throughout the draft. Do you want to go through from start to finish, or?
Right from the beginning, I think one of the things we had was we talked about the pricing unit, but we could not change that according to my notes because it's the way it's written in statute.
Yes.
So we had to leave it.
So we left that as is for now. I know it's out there as in SB 450. At this point in time, I don't know if we want to make the change to reflect potential. Yeah, Allison's shaking her head back there. So the answer.
Allison here.
Oh, no,
You
it's
want to
fine.
come up and join us?
I am absolutely fine right here. I will chime in though. Any changes, I did listen in this morning during the executive session, any changes that get passed, we have time to incorporate into our final proposal.
Oh.
So we can do that on the back end if those get passed.
All right. Thank you. That was on, I think, line 22 on page 1.
Correct.
Okay.
Yeah. So I don't think there was any other changes from a definition standpoint. Of course, this could be updated as we go through the draft and determine if there's anything else that needs to be defined. I think OLS will help us out with that. They want us to define anything further.
Yeah.
But for now, this is just a recitation of the definitions in statute, and they should be word for word from statute.
And we did also in Senate Bill 450, instead of having one alternate, was members of the Senate, members of the House appointed by the Senate House, and also the governor that we have now, hopefully two.
Yep. And again, that's something we could, I think, update once, when and if SB 450 is passed. Membership terms, those are all just directly from statute, as is quorum. The chair, the meeting section, advisory council. So all of page 2 is essentially just recitation from the statute. It's word for word from the statute.
I see change the word evaluate, but it says here elevate. but thank you.
Oh.
Good catch. On top of page 2, Senator Rosenwald is one of the catches we had on the English language that.
I think that might have been
Line 2,
Allison
was
changing, right?
Allison, somebody-
Yeah, I don't recall making that
Yeah.
change, so.
Any notes that I took, other than
Yes.
a few comments that we have on a draft, have been dealt with.
Powers and duties of the board is once again, I'm on page 3, starting at line 29. Another recitation of statute with some minor changes to reflect the rule citation. So, for instance, beginning on line 35, to achieve the goal of A above, in the statute, it would refer to the statutory provision as opposed to the rule provision. So those were just minor changes made to reflect that, those aspects.
That's all of us saw. We had a comment before on line, the word above, on line 46, same thing, determined from A above, it's back to being.
Yes, yeah. So that was all just to reflect the rule language. On page 4, again, it's just further recitation of the statute. There may, if memory serves, I may have broken it up a little bit differently, but it's the same. It's word for word the same thing as the statute. I don't see any notes here.
I see we added G, which is back to on line 20,
Okay.
was the confidentiality of the data.
Yes, and then we did, and I guess as a foreshadowing, I did go back through the draft, and we'll talk about that a little bit later, and added a more robust confidentiality section. It had been in a previous draft and had inadvertently been removed for the last board meeting, so I put that back. So we'll be talking about that later. Moving on to page 5, and I think this is where we start into some of my more weighty notes, I should say. So lines 1 through 12, again, are really just further recitations from statute. The one notable change is in line 7. I took out the year. The statute has the year by which the board was supposed to begin reporting. I just removed that year because I believe that since we're doing it every year by November 1st, it made more sense to talk about when as opposed to when to start. So that's all that is.
Where are you?
I'm sorry.
Line
So
7,
we
page
can
5.
number some aside.
Yes, I apologize.
Oh,
Page 5,
Yes, okay,
line 7.
thank you.
So down on line 17, still on page 5, K1. My note here is that we need to have the board decide how we were going to define 25 most frequently prescribed drugs in state. And I don't know if we ever came to a conclusion on that.
We
last-
had a discussion, but it came down to what is in the database that the state currently collects. And we collect an all payer claims database. And in the all claims database, a prescription is considered a claim. So we want to use the word prescription or claim, but that's what they measure within their system. So every time you get a pharmacy, you pick up a prescription, in their system, it's called a claim. So I don't know if you want to use the word prescription in parentheses claim or how you want to reference that, but I'll defer to someone who's got a more legal background. Jennifer?
Well, I don't have that, but there must be some prescriptions that are never filled and never picked up. For example, in my own family,
Yes,
my husband's physician sent a prescription to the wrong pharmacy. And they call me every day saying, when are you gonna come pick up his prescription?
Right.
When he's never going to, because he had them send it to the right pharmacy. So I think I'd be more comfortable with claim,
claim, okay.
because that's picked up and paid for.
Right. Because that's a good point, because my understanding is that the only thing that's reported, the ones actually paid for versus the one being processed, right?
Right.
And how would you, if you didn't, if they weren't in the all payers claims database, you couldn't measure it anyways, right?
Correct. That's the only database we have today that we can measure anything against.
So I think your comment, Mr. Chair, about high prescription with a parenthetical as reflected in the all payer, is that what you were suggesting? That makes
Basically, how to
sense.
have reference the language in the rule is actually what's in the database, because the database is considered as a claim, but we consider it a prescription in there. Paid prescriptions. Because a paid prescription is something that generates the claim. If it's percentage Rosewell, it never gets picked up, it's been processed, but it never gets paid, then it doesn't go into the database.
Right. But there's no other mechanism but for the database of measuring the most frequently prescribed drugs in the state.
Not that I'm aware of. Actually, I talked to Mr. Chalmers.
Charlesman.
About that. And we're actually working on a report, to have ready for you folks on May. And we're starting to generate some of that data so we can look at that over the period of time. He's broken it out by Medicaid, Medicare, and commercial payers.
So self-pay is not in there, right?
Self-pay is in there, whether it goes through on the commercial side, I don't know. I'll ask that question. Senator. I don't know if it's going, they only collect things that are paid by the insurance company versus self-pay. That I don't know.
It used to not be in there, so I don't know if it,
The question is whether we have
Has
self-pay. I'll ask that question when I speak to him. We can get that cleared up for that case.
So we
So-
actually need to give language today, so we can vote on this today.
So what are you thinking about? Is it frequent prescribed drugs in the state by paid prescription? Or by claim? And then in parentheses, paid prescription? But then that's back to the same thing, it's paid prescription. If you self-pay, it's paid, but it doesn't get into this.
We cannot do parentheses.
Okay,
I'm sorry. I have a lot of bad news when I come to these meetings.
You
Um,
do.
I do like the language of paid prescription or potentially the 25 most frequently prescribed drugs in the state.
Why not buy
Yeah.
filled prescriptions?
because you could fill it and not pick it up, and it wouldn't be paid, which is what. Okay, about this.
Technically, a paid claim is when it is adjudicated, so it's not necessarily picked up. So there are adjustments to the database when, so you get the phone calls, remind you to come pick up your prescription. If you have to get them on the phone, and you tell them you're not gonna pick it up, they reverse it out then. Otherwise, they wait. I think most changes a policy of 2 weeks, and then they reverse it.
Reverse it.
So then the next time they would send a fee, there would be adjustments for ones that were returned to stock because they were never picked up, but it's paid at the time it's adjudicated.
So the question is gonna be by two things. One is with who's paying for it? It's the insurance and self-pay, and then the question of timing of what's gonna be saved in the database.
Completed prescriptions. That would be fuzzy enough that it can mean anything.
Things we're trying to avoid.
I would say we're working on from, I think the denominator is gonna be is the claim, the prescription.
But the claim's a problem.
Claim's a problem, because claim doesn't tell you. That's the definition of it. By
Well, you could be very specific. You could say prescription paid for by the patient or completed
and picked up.
and picked up.
because
That's not the way it's reported. It gets reported by how it's adjudicated. And then those sometimes get adjusted a couple weeks later. because they get reversed out.
So it would still be eventually paid, because if you paid and then reimbursed, you're not paid.
But I think that Senator is correct that self-pay is not in there. So your paid claims that are in that all claims payer database are claims that have been adjudicated and paid by the insurance company.
Mhm.
And those could later get adjusted out. And I don't think there's any report of claims that were paid at the pharmacy level by the member when they come pay their copay or if they're a cash payer.
I hear this, I'd say at this point in time, given the fact that we may not be perfect going out of the gate,
Mhm.
is to at least have something to start with. And if you're looking for, talk to Allison at this point, 25 most frequently prescribed drugs in the state as defined by the rules.
You don't necessarily have to
I would
say
say-
as defined by, you could just say, 25 most frequently prescribed drugs in the state. Again, like your conversations prior, by claim, by prescription.
Do we need that? Do we have to?
Oh, if we can end at state,
That's what the statute says.
yeah.
Then it'll give us more flexibility into how we're.
I mean, we may
gonna
have an
define it.
OLS comment to that, just asking how we get that information, but I think it's a starting point.
So that's what
So
the
that's fine.
statute's there, just delete it all together.
Okay.
Yeah.
Takes care of that.
But may I make a suggestion,
sure.
Mr. Chairman? So the 25 most frequently prescribed drugs in the state, and you needn't actually say what the measure is. You could simply say, comma, as reflected in the all claims payer database or such like database then in use in the state of New Hampshire.
You could do that, yeah,
That way you don't get to
Yeah.
the granularity.
we'll get caught up into it.
So what was that language again?
So the 25 most frequently prescribed drugs in the state. And then I would say, comma, if the board is in the state, and just say as reflected in the
In New
All-
Hampshire,
in the New Hampshire all claims payer database.
But then you're missing self-pay. So should you be even more vague than that? Should you say in available databases? Or do we need to?
I
Do we need to say anything there?
yeah, I'd say if we just leave it alone.
Do we care about self-pay?
Oh, we care deep.
Yes. They're the ones that-
It's
but
about
right now, for what we're
public
trying to do
payers.
now, because we're really talking about.
Public
back-
payers.
Public payers, so if somebody's
Right.
self-paying, then a public payer,
Oh, that's true.
So maybe we can just stick with the all
truncate it,
payer
I
claims database.
yeah. As reflected in the Hampshire Health Claims Database. Or as available. I don't want to say it, I don't know.
I said as reflected.
As reflected, it's fine.
In the it's all claims payer or all,
Yeah, that was all payers.
All
All payers
payers.
claims database.
All payers.
all payer claims database, but then I would put the comma after that,
I would double check that name though,
Okay.
right?
before you finalize it.
And then I would say, or such like database then in use in the state of New Hampshire. In the event that this one doesn't exist or somebody changes the name, then we can't use it.
What was that
Agreed.
last language?
Or whatever the database name is, the proper name, as Senator Sherman says, then put a comma and say, or such like database then in use in the state of New Hampshire. Unless that's objectionable. I'm kidding.
I mean, you never know, but let's just go with it for now.
Go is what they say. Okay. 25, again, the total amount that's actually submitted to the all claims database. There's two components to it. There's the amount that was paid by the insurance company and the amount that was a copay by the patient. So when we talk about total cost, I think we can be clear, it includes both the insurance as well as the patient. So it's the total amount has to reflect both the insurance company and the payer, the patient. Yeah, we can subsequently break it apart. I've got Andrew kind of working on that, see if we can, because what I'm looking for is that we're shifting things from the insurance company onto the payer, to the patient. So we're not going to get involved with physicians which is Part B on Medicare and office administered.
Well,
Drugs,
this is,
right.
as Senator Rosenwald said, this is really focused on the state.
Yes. So that kind of thing. Okay,
So,
going once, going twice? Allison?
Yeah.
Okay,
So, sorry, yes.
so do we need to put down total amount spent, by the insurance and for the payer and the patient? Or leave it silent? Because the other one's gonna go,
I would just leave it as
Leave it as-
reflected, because
Yeah.
then you got wiggle room to do it however you want.
and I'm sure jail car will put it back.
Oh, absolutely.
yeah, we're not shy.
The same thing at 25 year-over-year drug cost is leave it alone, and not get into the granularity at this point in time. A lot of the board has, okay, if we just take out based on the NDC number, we can, when we ask for reports, we can ask for that granularity at that point in time versus it being the rules, we have to have written the rules that way. Or be able to have reports, and modify the reports based upon what we see versus going through this whole process all over again because we locked ourselves into it.
Well, I think that's always the risk of rules.
Yes,
I think you can end at state.
that's fake, thank you.
Yeah.
Okay, we'll delete that.
So that's for lines 23 through 24. Okay. And I just want to make sure I have the change to line 17 correct. So it will read the 25 most frequently prescribed drugs in the state, comma, as reflected in the New Hampshire All Payers Claim Database or such like database than in use in New Hampshire. Okay,
Sounds good.
all right.
And on line,
What did we do with 20 and 21?
we deleted 20 and 21, it truncated the after state. Not get into the granular. Bill Carr pushes back.
Okay, wait, I'm sorry. I thought you were on lines 23 when you deleted.
20
Yeah.
and 21
So, okay, so 20 and 21
deleted.
are
And then-
deleted. Okay, got it.
And then 24 after state, and
Yes.
25, those are.
Okay. Okay. And then J, on line 27, the board may apply for and receive funds, grants, or contracts from public and private sources. I don't think there was anything controversial about that. Moving on to line 30. 31 through 32, the board shall limit access to any information that it receives pursuant to this section, the smallest number of employees and other personnel possible. This is just to reflect data security, maintaining data in such a way that to lessen breach or anything like that. I don't have any notes next to it, so I don't think there was any questions with that.
Before we leave this page,
Yes.
could I ask that we take a look at line 8? Their strategies. I'm not sure what the antecedent of that pronoun is.
Senator Rosenwald, you're embarrassing me with basic grammar that I don't understand.
So whose
Yes.
strategies? Is it, if it's the boards, it should
Oh.
be its, but maybe we don't need a pronoun there at all.
I think I took that right from statute.
Ooh,
Hopefully I did, or unless I'm just making things up.
Does it reference the board
Yeah,
or targets?
let me check my phone here.
Could be it's instead of a
Yeah,
there.
it could be.
Yeah.
I'm assuming it references board.
That's my assumption as well.
Could we make it its? No apostrophe.
You said
Yes.
yes.
Okay.
We want to make it it's.
Yes, make it it's.
Really quick, actually, before we leave the page.
Yes.
The new section that was added, I did make some formatting changes. I changed the first group of 1, 2, and 3 to the new B, C, and D. Renumbered B to E, so now it's E, 1, and 2, and 3. That's just rule formatting.
Before we had it 1, 2, and 3, you change it to A and B, and then underneath it, put
Okay.
subparagraphs into it or subsections.
We went through that last
Yeah,
time,
we
right?
did. So it's just more of a formatting, right?
Yes, that's all. I didn't change any language. Yeah.
Just for everyone's edification, it does say there in statute as well.
It's the
That's all right.
Yeah, no, last.
You do have authority to change that.
We can
in your
change that,
language.
okay.
All
Right.
right,
Yeah.
Where is it?
right here,
Line 8.
line 8. Should be, it's referring back to the board.
Oh.
All right,
Um,
page 6.
So lines 1 through 3 are just continuations of the data reporting, compliance and data management. Again, it's just limiting access to confidential information to smallest number of individuals. And then 5 and 6 is relative to violations of trade secrets laws by the board for staff and the HHS. So, then moving on to line 9, which is the beginning of chapter 200, which is our appeal section. Again, we have a purpose and scope section. I don't have any notes here. The definitions, I don't also have any notes there either, but these were borrowed heavily from the insurance department's rules and modified appropriately. So most of them have passed jail car muster before.
Looks like it's basically the same thing here. There was a question on contested case means contested case defined by RSA 541A, which is down here. If you look at, again, line 41. So that was
I don't have that.
in my notes here.
Okay. What's the question?
There's a question about it here. I had it highlighted. Contested case means contested case. We define it.
Oh,
Clarify the reference.
oh, okay, got it.
Yeah. There was another one we talked about too. I think Rob is on the page 7. Or we get there before the appearances before the board.
Oh, yes, I do have that note as well. So lines 10 through 30, I believe are unchanged since last board meeting. I don't have any notes.
There was one under, if you go back to and look at line 18. We initially had 2 weeks, and we changed that to 5 weeks.
Okay.
Then also, if you go back and look at the line 30.
Yep.
It says at that point, in time the board may waive, it says the chair may waive. Change it from the board to the chair.
What number, what page number?
On
7.
page 7,
Line
line 30.
30.
Because initially, the first draft had the board may waive.
Okay.
We talked about that, and we said it'd be more for the chair, if there's discretion to make.
So you're just pointing out changes that we've made since the
Yes,
last draft.
so we're all the same.
Correct.
So now the question that we still have outstanding on my lines 34, 35. Last meeting, we discussed the board had discussed the potential for unauthorized practice of law. And I have in a note here that we never come to a decision as to whether employee would remain in that section.
I think the question, if I remember what it was the fact that when someone's before the board, they have the authority. We don't, it's not someone lobbyist, if you will, but somebody who has the ability to bind the company. I'm looking at Todd here as the attorney. We want to be sure that if someone's speaking to the board and representing the company, they in fact are speaking on their behalf, they can be held accountable for what they're saying.
Well, the company can be held accountable for what they're saying.
Correct. On behalf, that they're truly representing the company.
I would just say, or a duly authorized strike and officer or employee designated to represent a business entity. So they're duly authorized to represent. So, or strike and a duly authorized officer or employee. Is there?
Duly.
Officer, employee.
Designated to represent a business entity.
It should be, shouldn't it be that business entity? I mean, I'm mincing words, but it could be any business entity
Yeah, that's true.
if you leave it at.
Right, no, I think
business.
that it's fine, that you're right, Senator. I would simply say at that point, I mean, we would look at them as a board and say, are you authorized to speak for, are you speaking for a petroleum producer, or are you speaking for a pharmaceutical concern? So, but yes, I think, yeah, that business entity,
Just get rid of the A and put
Like
that.
Yeah.
good catch.
Otherwise, Jim could just represent everybody.
I can't represent anybody now.
You're an attorney at law.
Oh, I'm not.
Oh, you're not? I didn't know that.
Trying to squeak you a little wire there.
I think we're all set. Yeah.
JJ?
Yeah. we're on page. So
That does actually, Jim just made me, because he said he can't speak on behalf. Does it have to be an officer or employee of the company? What about somebody else? They're not an attorney, but they're authorized to speak on behalf of the company.
What you're trying to do is you're trying to find whoever is speaking
To the company.
to the company, so that their words are binding upon the company.
So it
And
doesn't-
by definition, a lawyer would do that. When a lawyer speaks on behalf of a client, they bind the client.
But what about the second part of that phrase? Would it have to be someone who is employed by the company?
Well, when I say, the reason I put in duly authorized, employee designated. We could, are you suggesting we put somebody else, a duly authorized
it's a-
agent?
What if
The
it's a
agent
board
is a good
member?
word. What about agent or,
Then I think it gets more complex because,
but Jim's right, he would not be able to speak on behalf of the company,
But this,
even if he were authorized.
when I go back to the reason why we're doing this, they're coming to the board because there's a reason why the board's called them. It's not taking testimony. We're taking somebody who's coming before us who's got a violation of something that ages is the process of repealing. So it's really coming down to it saying, we're gonna call a company before us to have an explanation to what happened, which is different than Jim coming before us, like can give us a presentation. So it's a different type of appearance before the board.
Yeah, but I'm not sure we're the ones to decide who a company authorizes to speak on their behalf. right?
Usually you would see a written authorization authorizing person X or Y to speak on behalf of the company, because in the adjudicator proceeding, you want to know that whoever was representing facts to you had the authority to bind the company. So that it's not just an exercise in pleasantries, it's
Right.
when you make a decision, it's going to bind the company based upon what it is that they say or not say. Like say somebody comes in and says they didn't get notice. Well, how do you know they didn't get notice? I mean, what authorizes you to speak for the company Y or Z?
Why wouldn't it just read, a representative shall either be an attorney, a duly authorized attorney at law licensed in New Hampshire, or, because the attorney still has to be authorized, right?
Attorneys wouldn't speak without authorization. They would
Okay.
never do it.
Or why wouldn't it just be a duly authorized agent designated? Because then what I'm getting at is officer and employee are both employees of the company. So why are we putting in that requirement?
Because an officer presumably has the authority to bind a company. And a duly authorized employee could, by virtue of some express authority in a designation, speak on behalf. It could be a North American vice president who's maybe responsible for appearances before the PDAB,
Right.
who's not an officer.
But a duly authorized Jim would not be able to do that.
Duly authorized Jim would be acting as an attorney, I think.
Except he's not an attorney.
Correct. So it's not authorized practice.
So
of
he
law.
couldn't, as he said, he couldn't speak.
I think that's right.
Well, so I was just curious though, because the way this is worded, if it means even a citizen who wanted to come before the board couldn't come before the board. Do you need something in A that says a person or party may appear before the board in person on an adjudicated matter? But this is pretty broad. So are you really limiting the only people who could ever come before you at all are representatives under your definition?
Doesn't a representative though mean a
It's a
representative of the
representative
company?
capacity, not in your own individual. And a citizen could always come before us speaking in their own capacity. I think, Jim.
So what I'm trying to understand, that you made this point, Jim, where there's gonna be times in which, like we had in the past, we've had people come to the board and do a presentation. So they appeared before the board, but it wasn't adjudication, if you will, or something in which you're trying to make a determination about a ruling. So if you're basically coming before the board to provide information, that's like you do in the House, you can come anyway, speak on behalf of provide information. But if you understand it correctly, if you're coming before the board because the board's adjudicating something, then at that point in time, you're appearing on behalf of the company. That's a different than coming before the board to talk about what's going on as a lobbyist or anybody.
So actually, I think it's simpler than we're making. Because up in A, up above, it says a person or party may appear before the board in person through a representative or both. And then what we're trying to define is the word representative. So anybody can come before the board. And the only question is if it's a representative, what's a representative?
Needs to be a person with actual or implied
Authority.
authority. One, or it needs to be an attorney representing that entity.
So I like the word agent more than officer or employee, because the representative refers to a person or party may appear before the board in person through a representative. So it could be anybody come. So if I can't appear in person, I could have Jim come as my representative, but I would have to authorize him.
Yeah. If you got company authorization.
Does that make sense, Brian? Or am I not?
I think you're expanding agency to acting as an attorney.
Yeah.
I think that's the danger.
But I might not have an attorney or an officer or an employee, because I might not be a company. I might just be a person.
So when the stakes get high, and I'll just put it out there, you want to know that whoever's speaking is speaking truthfully and they're binding when the stakes get high.
Right.
And I'm not saying that any class of persons wouldn't do that, but there's a different standard on lawyers speaking on behalf of clients in New Hampshire. And I think there are many situations in the rules where, whether it's the PUC or other agencies, where they want to be sure that whoever's coming in it is absolutely binding. And that's why I don't like, agent can be anybody, right? And it could be any person.
So, but what if I wanted to speak before the board and I couldn't be there, so I authorized Cindy to come and Senator Rosenwald to come and speak for me.
Under
She's not an
under
attorney.
Power of attorney. I mean, I don't know if we'd have to accept that. I don't know that I would be, I would be honest with you, if it was a matter of importance for this board, and no offense to the senator, but I don't know, if she didn't know your mind and your heart on an issue, I don't know if I'd want to necessarily accept her testimony on your behalf.
Even if I authorized her.
Right.
I mean, would anyone recognize it as binding?
Right.
That I could say, oh, yeah, sure.
So I
Cut
guess
his
what we're saying,
prices.
what we're saying is a representative, we're talking about a representative of a company.
Right, which is different than somebody appearing before the board,
Right.
which is good. You raise a really good point, Thomas. On line 15, that's means anyone can come before the board, but that's different than somebody representing a company.
Right, so the problem with line 15 is it says that a representative can come for anybody.
So maybe I can shed some light on what my thought process was for 202.02, was that was in a contested adjudicative proceeding where 15 was supposed to be just anybody coming to give their thoughts to the board. I don't know if it's necessarily clear.
Oh, so it's not defining representative above in 15.
Yeah, so it's more, that was my intent, but if it doesn't read like that, then we might want to.
But what if you put in a representative of a
Business
of a
entity
business
shall be-
entity? You're defining that.
Well,
Jim.
you define adjudicative proceeding, but I don't see where you've used adjudicative proceeding anywhere in this. So you've defined what I think you wanted this to apply to,
Mhm.
but you never then use the words that you're defining. I can't find adjudicated proceeding anywhere in these sections.
It's possible it was removed through various changes, but I think this would be a good place to use adjudicative proceeding.
Well, otherwise you're defining something that you're not even using in the rule.
So is it in 13, would you say who may appear, or actually 11, is it appearances before the board for adjudicative proceedings?
On what line are you?
11.
Yeah, we could do that. Well, actually, no, that because 202.01A is for just general appearances before the board.
Okay.
So I think to
What
use.
about 202.02?
That would be a good place.
Representatives for
Yeah.
adjudicative proceedings.
That would be a good place to put that, yeah.
That makes sense. It's way from the park.
And then we can leave it just representative, because it could be any representative has to hit this high bar.
Yes, for an appeal.
Is that right, Todd? Do you agree with that?
I don't know if I can answer it directly, but I think if and when I sit on this board and there's an adjudicative proceedings, I want whoever's sitting in that seat to have unequivocal authority to bind the company and to speak truthfully about the company. So we have, and there's no wiggle room on it, and it's either an attorney or preferably an officer of the organization. You know, that would be ideal. That's what I want to see. The further you get away from that standard, I think the more dangerous it is for us.
So that's why in 35, if we're defining representatives for adjudicative proceedings, then we want that high standard in 37 and 38.
That would work.
That makes sense.
We're gonna change that heading in 35 to representatives and
So,
adjudicative
On
proceedings.
line 13 of the law, that's just general appearances before the board.
Right.
Line 35 is when you have adjudicative hearings. Adjudicated hearings,
Which
right?
triggers a higher
Which
standard.
triggers a higher standard
And that's proceedings, right?
proceedings, correct?
That's the word. And then 37 and 38 is representative shall be either an attorney at law licensed in New Hampshire or a duly authorized employee designated to represent that business entity.
Yes.
So not officer.
Yeah, it's got a duly authorized officer or
Or
employee.
designated
Needed
to represent that business entity.
So Todd, do you want to infuse the word employee, or do you want to leave it at duly authorized officer?
Both.
I'd leave both.
Both, okay.
I'll be asking that question as soon as they start to speak. If I'm on board, so.
So where are we placing adjudicated proceeding?
After the word representative,
Okay.
representative for
Thanks, Jim.
So
Oh, I think
You
that's- I think that goes-
can I just ask him too, starting on line 44, we're not going to require that we find out what their role is, why they're able to represent that business entity? We just want to know who they are, what the matter is, and how long, but not what their capacity.
I think 50, Senator deals with that. And if we just change
Duration
duration of
of-
designation and scope of authority
Okay,
okay. So add on
and scope of
Okay.
authority.
scope of authority, right?
I just have one thing, representatives for adjudicated proceedings, we're adding that to the section title, correct, is that?
Yeah,
Can we also add that to A, so it would be a representative for adjudicated proceedings shall be,
Yeah, oh, we are
so
doing
put
it.
it in both places?
Yes.
Okay,
Those are both sides.
perfect.
So Jim, you just, under 13 through 34.
Anybody can
Anyone,
speak on it.
right.
That's what it says.
so you saw the job.
So, yeah. Okay. And I have a note here that we did also change it from 60 days to 90 days in the calendar. Sure, is that where we put that change? Look at my notes before. It was under the advisory council. I might use it next. Issuance civil fines.
Okay,
I'm way ahead of you, so I'm
all
sorry.
right. So we good to move on to page 8?
Can I just ask one last question on page 7? Sorry. The last on line 52 through 54, it says an attorney from another jurisdiction shall be permitted to participate in the proceedings if the attorney files a motion for leave to appear, providing proof the attorney is in good standing in his or her home. I would change his or her to their, gender neutral. So that's the only place. But the real question on that one is, where do they file a motion? Is it with the board?
So usually when an attorney wants to appear in another jurisdiction that they're not a barred member of, they file a pro hoc vice, I think is the petition, yeah, with the court, and they have to get an attorney who's currently in good standing in that jurisdiction to say, yep, I'm gonna watch them.
So
They're
there's
gonna-
an existing.
Yeah, this is a normal process for when we just didn't use the legalese. I've never had to do it.
So the attorney who's in New Hampshire license is covering the other person.
Yeah, but basically, they just sit next to the person and they collect a nominal fee while they're busy doing their email and the other person's good.
Sounds like a good
Doesn't
job.
always go that way.
That's me being facetious. But they are under your license in that circumstance though, too, so you do have to be cautious. 8, on to 8. So standard, nothing about unauthorized practice of law. It's important for our purposes. And then right to counsel is the standard right everybody has. This is all from the insurance rules modified for our purposes.
we're gonna have to change line 2, his or her.
Do you guys use gender neutral pronouns?
It's starting to be a little more accepted. Typically, it's his or her. But we've been trying to goes there, and so far so good.
Okay.
No.
I mean, we can just do a.
Find a
Find
replacement.
a
Yeah,
replacement.
I can do that.
We're gonna be the hippest board, or this most politically
Correct.
Proceedings, yep. Looking to see if there's any notes or comments. Oh, down in, my numbers are a little off because I have comments on mine, so I apologize. I have to let you scroll, but in lines 50 through 51, we need to take out the parentheses. Is that correct, Alice?
Yep,
So we have to get some parentheses.
Yeah.
so I just replaced them with commas.
So we leave
What
the
was it?
words in, but replace the parentheses with commas.
Okay, gotcha.
That makes sense.
That's all right.
I think everything else was from my notes. I don't think we made any other changes, but I'm working up a different draft than you.
Just want to work again, people's attention on 53 and 54. And separate the fact that, again, judge and jury, that the advisory council, the role would be at that point, if the board feels that they may not have their pieces of where the advisory council put you on it, take a deeper dive into it, then come back to the board with a recommendation.
I think that's a spectacular idea, Mr. Chair. I wonder if we should just put in definitions advisory council
Yep.
Yes.
and then capitalize it.
We can go back to that.
Sorry, we didn't capture that last time.
In rule text, please do not capitalize advisory
This
No,
is bad news.
council. Unless it's a federal entity, do not capitalize it.
So this is the same as OLS and bills, right?
Yes.
Right.
But in our notices that we have to file with our rules, it's complete opposite.
no.
So we have the 90 calendar days.
Which is on line 1 on page 9.
Okay, so my numbers matches yours again. After some comments.
We changed that, it was 60, we looked to 90.
Yep. I don't think we changed anything in 5 or 6. 8 or 9, I think it's the same as before.
There's in line 8, you've got a civil fines. There should be civil fines
Just-
or a civil fine. Can't have it both ways.
My fingers are just too fast. All right, so I'll make that change.
Also, I think we talked about,
Okay. And then 20, starting on line 21.
page 9.
Yeah, page 9, line 21.
Can I ask a quick question before we go on?
Sure.
It looks like there's only one time frame in 20201. Is that correct? Oh, no, there's two, sorry, never mind.
Um, 21. Yeah, Mr. Chairman, I don't think I have any notes of changes
Yeah, let's see.
there. I think we're ready for page 10. I believe this is all the same from last.
What do you mean by durable paper?
That's what was in the insurance rule. So you'll have to ask them.
That's it. I just had to throw that out.
I think,
else to
I
that.
believe that's also in the department's AAU rule, is that we have to have durable paper as well. I don't know what that means. either.
Acid-free archival. I mean,
I guess you can't rip it up. I don't know.
It doesn't dissolve.
Yeah, I mean, I'm not married to the word durable.
No. If we understand the general.
I think it's, yeah, to prevent the people from using like a napkin to file motions, which I think has been done before. So I don't have any other notes on page 10. I think it's all pretty much the same as before. I think. Oh, I'm sorry.
We did change on page 11 on line 7. It's calendar days.
Okay.
Versus days. So they're about calendar days. versus confusing with business days.
Yes, I think most timelines are calendar days in here. 2308 is just confidential documents, beginning on line 19, for the purposes of adjudicated proceedings. So I don't know if we want to specify that.
I think adding the words for adjudicated proceedings after information,
And which line do you want?
19.
so if some random person just comes and talks to the board, that would not be made public if they had written remarks.
Think it's maybe public comments.
But it wouldn't be
But that wouldn't be
public
an
document.
adjudicated proceeding, right?
right.
So that could be public.
But we don't want,
Oh, I see.
Which line do you want?
um,
Which page?
19,
Page 11?
yes. So we only want things, documents as part of the adjudicated proceedings to be public. Other letters to the board, we don't.
I see what you're saying now. Okay.
Yeah.
I'm
It's-
missing.
So it's actually documents that are shared with the board in the public session. Are
It
available
wouldn't
for the
be
public.
made public unless it were an adjudicated proceedings. If we do what Senator Sherman is suggesting. But is that what we want? If somebody writes a letter to the board saying, I think you guys are doing a great job, or you guys don't know what you're doing, it wouldn't be made public. And if we made, if this section was only about confidential documents and information about the adjudicated.
Oh, I see what you're saying.
You know
Yeah.
what I'm saying?
So it limits it so that what's underneath
I think,
doesn't apply to other things.
and is that what we want?
I think we probably want it to apply to all confidential documents and confidential information in the hands of the board, right?
I do have a separate section for that. I think we actually might have passed and I just had to name something different.
41 or 42, about ensuring confidential information for the filing party.
Well, I mean, again, my intent with this section was just to apply it to adjudicated proceedings, but
There's another place where we handle it.
yeah, well, I'll go back and look again. Make sure, because I'm sure that last time another section of confidentiality that still in.
I thought you did a nice job drafting these, frankly.
Oh, thank you.
20308, 21 and 22 says anything submitted to the board is public for public inspection. And then you said on lines 41 and 42 that if somebody wants to preserve confidentiality, that they need to redact it. And the person filing needs to ensure, I mean, we don't know what's confidential, I mean, necessarily.
Don't we have, I'm getting a little confused, don't we have proprietary information that we cannot release under any circumstance?
But if somebody comes in and files with the board and thus by filing makes it public, it should not be our burden to start saying that's.
But what is the
giving
filings with the board?
Could be anything.
Mr. Chairman, someone raised their hand.
Oh. Yep. Yeah.
He's muted,
I just allowed it to talk.
but is
But
he,
we have a speaker who would like to raise the hand, Donald Feinstein,
Funstein?
Feinstein?
He's muted. Donald, you're muted.
Mr. Feinstein, you're muted. Can you unmute yourself, please?
Are you able to mute him? or-
I clicked allow to talk, so I don't know.
If you click on the microphone. There's nothing you can't click.
Can you go back to participants and see if you can pull them?
Oh, we can unmute him right there.
That's the mute.
It's up to him though.
Yeah.
Mr. Feinstein, you have to unmute yourself, please.
What's under more? Not when you're moving.
You can, we can, if you want to temporarily promote him to panelist, and then that may help as well. You can always-
Well, he can unmute. I think he just needs to unmute himself. Okay,
Okay.
so. I'm just, let's just walk through a couple scenarios. So anything under this, anything that is submitted, all pleadings, attachments, to police pleadings and exhibits submitted at meetings shall be available for public inspection. So that has to exclude proprietary information because that's remaining confidential. So when a drug company sends in their proprietary information that's required by the board, where is that confidentiality section?
So, yeah, I tried to address that and I kind of glossed over because I don't have my helpful highlighting my draft. You'd have to go back to page 5, 102.08 is where I tried to capture that.
Oh, there it is, down
Yeah.
in 37.
Yeah. I apologize for kind of skipping over that, but that's where I tried to address.
So
yeah,
that would fit under the phrase except as otherwise provided by statute or rule.
I would hope so. That's my intent, yes.
Okay, we just have to be sure because
Yeah.
there's a trust that we're developing with,
Correct.
with-
And I know that was something that was brought up last meeting. As I said, it was inadvertently taken out of the draft that was viewed last meeting, so I tried to bring it back in for this meeting.
So if we go back to page 11, under line 22, back to what Roosevelt was asking for, is not all documents have to be made available, but they shall be made available if the public wants to see it, 91A.
Unless there's some other
Which is
exception.
back to what you were saying before.
Right. There's some other
Otherwise provided by statute or rule, which is outlined on page 5, line 37.
Which is different than us having to release it, but somebody wants the document, they're entitled to it.
No.
Not the confidential ones, but anything it's basically, unless it's protected somewhere in the rule of statute,
Right, then it would become.
91A.
And 91A, I believe, does explicitly protect trade secrets from disclosure. If I remember correctly off the top of my head.
So on line 22, do we have to put down public inspection per 91A, or just leave it blank, sound?
I mean, I think it kind of implies that 91A applies, but I don't think it hurts to have that,
Why don't we
explicit.
put it in for 91A, because that way it will refer back to the statute.
I mean, ultimately, that's what's going to control.
In the statute, it does like 91A, if there's copyright, so forth, it's not required to be released, which
Right.
also goes back to our rule, right?
Can I ask a question?
Yeah.
So what you're basically saying here then is if a confidential document is turned in, the burden is on the submitter to determine what needs to be redacted. So if it,
Yes,
right, that's basically
that's
what's
what they're
being
saying.
said.
That's what's saying.
Because
Okay,
how would anybody know?
right.
I just want to make sure we're not getting somebody in a catch-22 here,
That's what I'm thinking.
which is the board asked for a confidential document. That document is confidential, so the company or whoever is being asked for that document doesn't want it to be publicly available. Then if we go back to, so how are they protected? In line 43 on page 5, it says other information designated as confidential by the owner of the information. So what this is saying is that line 43, page 5 would qualify under that first phrase, except as otherwise provided by statute or rule. So in other words, it would remain confidential because the company, the owner of the information has deemed it confidential. So it would not be subject to public disclosure. It's kind of circular, but I think it still protects the information.
I can shed a little bit of light on that from what we do when we get right to know requests for RFPs is individuals will submit it and indicate what they believe is confidential. So if we get a request for, a public release of this RFP, we'll go through it and see if we agree with their assessment that it's a confidential or trade secret. We'll work it out with the individual. I know this is not exactly an apples to apples comparison here, but the burden is on the submitter of the RFP to indicate what they believe is confidential.
Right, so, but what I'm saying is that in this section 20308, either the submitter can say, because they own the document, that I want this to remain confidential, or they can redact it. But if they do neither, it's subject to 91A.
I still think we have to do an analysis before releasing.
Right, I got it.
Yeah,
But I'm just saying that in terms of the protections for the company that owns the information, they have a right to either redact or say this is confidential,
Or a motion to seal.
yeah.
or motion to seal.
I think we're conflating two things. One is in page 5, data reporting. That's when we start asking for information to why the price was and so forth, et cetera. That's very proprietary and so forth, et cetera. That's different than a hearing. So on page 5, we're talking about when we ask for somebody to say, okay, your price went up by 200% last year. Can you help me understand why? They may come back and say at that point in time is this is the reason why this cost went up, that cost went up, and so forth, but that's proprietary to them. Unlike on page 11, we're now into a hearing. So when you're in a hearing and you're providing documents to it, that's different than reporting requirements under 5. Now we're asking for the hearing, which is a whole different matter, I think. I want to be sure we don't separate, confuse the two, conflict the two.
And that's what I was going for with this, but apparently
Yeah, I'm just wondering if there should be a notification to the entity that the information, that the duty is on them to redact So there's no conflict later that the board shall notify of this procedure and then
So Jim, if I go back and follow your logic, which I think it makes sense here, on page 11, line 30,
Mhm.
when a person files a document, the person who files the document, they're the ones that have to be admitted or redact.
Right.
So is that clearly say on line 30, when a person files a document, the person filing the document shall omit or redact?
No, he's saying that they shall be made aware of the
procedure
responsibility.
before they omit, or so they know that if they don't do it, it's being released.
When a person files a document, or it would almost need to be something like prior to
Yeah.
filing a document. This is going to sound really redundant because I'm not good at this, but prior to filing a document, the person who is filing the document must be informed or shall be informed of the need to omit or redact confidential information from the filing when the information is not required to be.
Do we have, I mean, I hear what you're saying, but in a lot of ways, if you file the document, it goes back to the rule. You're basically saying they didn't read the rule. So
That's
therefore, they're gonna file a document.
That's basically it. Yeah.
They're happy to
I'm
protect
just
their-
saying.
They're trying to protect their ignorance, basically.
Yeah.
Is that what I'm trying to understand?
Yeah,
Well, having done that multiple times.
Okay, just wanted to be sure I did.
well, only because they may think from an earlier requirement that it's gonna remain confidential.
Right.
And it won't be under these circumstances. Now the burden is on them to redact, or it could be public.
Yeah, I think though the burden needs to be on them to be informed before they do that rather than on the board to inform them.
Mhm.
Although we could have a brochure that walks you through how to.
We do, they're called rules.
That's what I'm saying. I mean, that's just.
I mean, if you're a sophisticated player representing people with stakes as high as these,
You
I
better
would
read the
presume they're
rules.
gonna read the rules.
I almost lost my mornings.
But I do agree that when a person files a document, the person who files a document shall be the one responsible. We're not responsible. They are. Right.
So that's generally the way we do it. Yeah.
And it is reiterated below.
That's true. It's the responsibility of the filing party to ensure that they read the rules.
Okay.
I hear you concerned about it.
Right, no,
All right. Moving on.
I think so.
So did we decide to say confidential documents and confidential information for
Adjudicated procedure.
adjudicated
Yes.
proceedings?
We
Okay.
did decide to do that.
Okay.
And then we're adding 91A to 20.
Because that's what it will kind of.
Beat that one.
So we just make sure I have the wording right in accordance with RSA 91A.
On line 22, which is,
Yes.
yes,
I'm just a country dog.
for 91.
And may I just say one more thing about that? I'm really not trying to be at all cute with this. It's just that the stakes are so high with this, is that I would not want one of us to get it wrong, or the executive director, because they didn't tell somebody. Let's say there's a whole
Yeah.
slew, let's say there's 100 such filings that come in. It could happen, right? And then somebody forgets to tell 10 people and then they file. So that's when I say it's the rules. The rules need to be what people consult to. This is a software to operate before this board.
I would say the same thing is that when I was on the pharmacy board, people come and, you know, they do something and violate rules. So what it wasn't aware of. I said, did you read the rule book? Was I supposed to read the rule book?
Well, I've had occasions where people look at me like three heads, you know, in law practice, I'd say, could I have the rules of procedure? And I said, well, that's because I need to understand how you work. I need to know. And then sometimes we don't look at our rules. I'm like, well, I'm sorry, but these are your rules, right? So this is what you need to do, because this is what you told me when I read it, you will do. So, you know, these are gonna bind us and it's gonna help them, I think.
I concur. So moving on to page 12. On 12 now.
I believe we are. Yeah, I don't think we changed.
Wasn't much change there, and I have my notes anyway.
Yeah, no,
I added, actually, line. Oh. I'm looking at two drafts. I have notes on one from what I changed. All right. Back to line 14 and 15 of 12, the letter J was added based on the last meeting.
Okay.
That was one of the things we talked about, if we have a decision or something else, is so that people can go to the website. And see what past rules, past comments and so forth.
Yeah. Yeah.
Okay. It's the same thing you have at that recorded. That should be made available for the public. It should be out there. Okay, I'm with you.
So other than that, I don't think I have any other notes for page 12.
There's something. Going through and track with.
Page 13. And I don't think I don't.
Yeah, it's pretty clean.
Can I just,
Yeah.
line 5,
Which page?
page 13.
Okay.
I don't know when we last used a tape recording or stenographic notes, but I suspect, are you still doing it?
For our public hearings, yes, we record them via a little recorder.
Are you serious?
Absolutely.
So should we bring that in? What if we took out tape recording and just, I mean, tape and said the recording or
Recording.
stenographic notes? 'Cause then that could
Electronic,
be digital,
how about electronic?
Can't do that.
Audio.
can't do digital. Well, it could be video too.
A recording? Electronic,
I would just say the recording or
Recording.
stenographic notes.
Yeah.
okay, that's fine.
Is the word
Tape.
tape still used, like, is there a defined term in?
I don't.
No, and I actually believe, per
There is for
agency,
worms.
it might be per agency if it's recorded
I
or
would
not.
like to-
Oh, I thought all rulemaking had to be recorded.
So maybe it does. I know for us, it's in our rules. We have to.
And I'm pretty sure adjudicated proceedings have to be recorded as well.
So.
But it doesn't say tape recorded.
So we can just say the
the
recording.
recording, okay. Take
I
care of that
do
one.
have a tape recorder in my office as well. if you need it.
I
I
hope
have
it's
some
real.
little tiny cassettes too. You need any extras?
Well, our AAU, our administrative appeals unit, they still use a little tiny tape recorder.
Micro cassettes.
Yeah, it's, I mean, it's not uncommon for it to run out of tape in the middle of a hearing.
All right,
Just a real bummer sometimes.
so we stricken the word tape
Tape,
Yep.
as in worm.
Okay.
the rest of it, this page was pretty straightforward, I didn't see any based upon our comments.
Yeah, there was one, it's not there anymore because it was removed. So it would have been the old line 15, it used to be an H. And it just said safeguarding PIIC confidential information, so it's kind of just like a note. We decided we will do that, we didn't expand on it.
Oh.
We on to moving on 14?
I think so. I think I have 14. Allison, you?
There was a change to line 54. It used to say, and the following, and we changed it to which includes the following information. That was it for that piece.
Okay.
15 talks about actions on petition, it's pretty straightforward. Is there any changes in there?
I don't have any notes on.
I don't.
On page 14, there's
What's
a
that?
mention of 30 days, but it doesn't say calendar days.
Oh,
On
good
line
catch.
7.
Thank you.
Page 14.
Calendar.
Calendar. Got it.
Is 6 years a standard for keeping that's line 45?
On page 14.
Yeah,
I think every agency kind of has their own manner of doing things. At the department, it depends on what the information is. Like Medicaid information, we have to keep for, I think it's like 7 years. Because that's the federal requirement, but there's a general 3-year retention for things that don't otherwise fall into other categories. So 6 years, it was probably just what insurance had.
Yeah.
So I'm not married to 6 years.
No, I was just wondering where it
But
came
you
from.
could raise a good point though, Tom, because in a lot of ways, 6 may be too long in some cases and too short in other ones. Can we basically say per state and federal law?
Do we have
Except
a-
there isn't a state
Yeah, I don't
federal
know
law
if we
that
have to.
applies. So I would just,
There
I was
might-
just wondering,
Yeah.
I didn't mean to change it. I just was wondering where it came from.
There might be a general, I think there's a general statute about 3 years somewhere. I'm just trying to remember where it's
I
at.
prefer 6 over 3.
Well, you can keep
Okay.
6 too.
Gives you more
Yeah.
look back.
So 6 fine.
Right.
All right, on to page 16.
Oh.
Catch.
Grab the other. Range. Go through that. Okay, that goes. Okay, never mind. My notes are thrown off by numbering again. But on 16, I don't think we made the change to the percent there.
No, I saw that. So
So,
if you go on page, actually on page, it's on page 17 is where it's on the
yeah,
top.
so,
We had to change it. If you go back, which trying to get to, I think is on page 17, line 8. Shall not exceed 125% of the board's operating, and it's actually in Senate Bill 450. So in here, it's not 15%, it's 125%.
Oh,
Yeah, I don't get 120.
Yeah,
and
You actually caught that.
Yes.
Senator.
yes.
so I have the 15% in 2 different places.
Where's the other one?
I have it in 301.01A, and I get my numbers up, so.
Someplace else
Yep.
on. which
So,
page? Which page you want?
Page 16, line 8.
16, line 8. Yes.
And that's the first or the second place.
That's the first place in the actual full order, but it's the second place we've identified.
Where's the second place?
The second place is
Page 17 on line 8.
and that,
That wraps it up.
that's what we got.
It's great work.
Yes, good
Thank
work.
you.
Thank you.
Thank
Thank
you.
you.
Yeah.
Excellent. Thank you.
So should we do, we have a quorum, right? 4 of us?
Yeah.
Should we do a roll call or shall we do
We've done that.
that? If I now, yeah.
Yes.
And then
So-
we can vote on the rules.
No, I opened the meeting with the forum because
Oh,
Senator-
cool. Awesome.
Senator Overall was elevated to a member. As an alternate, so the alternate.
As opposed to analyze
Yeah,
or evaluate.
Right.
So
Okay, so we're all set.
we're all set. So at this point in time, you all have the vision. You got everything? Okay, I got my notes as well. So can I have a motion on the table to accept the rules as revised?
So move.
Second.
All those in favor say aye.
Aye.
Opposed? Abstained? The ayes have it. And may I have permission for the board to review the changes? And if it's approved by the chair, then move it on to,
The LBA over the
LBA.
fiscal impact statement.
Yes, so moved.
so move. All those in favor say aye.
Aye.
Opposed? Ayes have it. Also, I wanted to give you, it's in your packet, I did, Senator Rosenthal was at the fiscal committee. I don't know how it was received, that you guys have a lot on your plate that day, but it's just giving them an update that we are in fact moving forward with the rules. I wanted Chair Karen Representative Umberger and the rest of the committee to be aware of where we are in a rulemaking process. So that's kind of a more of a, based upon this, we're looking for, hopefully, I can get together with Rob and Allison, get the draft finalized, get it up to LBA, they'll do a fiscal impact, get it back to us sometime May 12th or 14th. At that point in time, we'll have to send it on to OLS, we'll have a public hearing. Now, the public hearing, how we understand it now. The public hearing doesn't have to be the full board, it just has to have the ability for the public to make comments. The board can be there. And I would encourage, if we can, in June. The challenge, though, is based upon the timeline. We agreed to meet on June 20th. We may have to hold a meeting for the board if you want the board to be involved with public comments, like in June 27th, following week. So it's up to your folks as far as your schedule, I don't know how tight they are, but if we can do something the following week, it's tight, it's definitely tight. It would then allow for the board to hear the public comments. And my understanding is it's not really a dialogue, it's going to provide us with.
Exactly.
Right.
So the public hearing, I do have this room booked, I believe from 11 to 12 on June 16th for that public hearing. It will be myself and chairman. I always suggest, if you know an answer to a simple question, feel free to answer it. But if it's not something you quickly want to answer, we just like to say thank you for your comment. They will be considered and we'll move on to the next.
So we have a public hearing, and the next week we've got our meeting.
So because in rulemaking, we have to have our public comment period open for a week after the public hearing.
So why don't we just meet on the 27th
I think of then,
rather than having two?
I think on the 27th, the week afterwards, will give us time to take
Yep.
public comments and so forth, and come back to the board with public comments and make any revisions to the rules and get buy-in or support from the board for approval. Then once that's done, then we can move it forward to jail card. Is that correct?
Yep, so our public comment period will end at the end of day on June 23rd. And then we actually do have some wiggle room, and I believe I told you, Representative, I am out during July job card. So we are pushing this off to August. So we do have wiggle room on the back end for us to revise anything we need to, work through OLS comments, because they can kind of take a little bit to get back to us and then move it from there.
So are we going to skip a June meeting except for the public hearing and then meet in July? You're going to be gone in July.
I'll be gone the July gel car, so we're bumping this rule up to the August, so I can be there for this.
But
So
Joe,
we need to have rules done before August.
Oh, yes, so we'll have to file by July 28th, and I'll be back in office by then to do that. I'm out.
Well, when does the board, when does PDAB have to have the rule making process done except for her file?
so when does the board have to sign off on the final set of rules of going to jail card?
I mean, we could do it on July 27th, if you want to, because it's not, it doesn't have to go to the commissioner, so there's no week-long period for her review. So this is a little quicker and on our timeline. So as long as between the end of the public comment period on June 23rd through July 27th, we have that entire time to work on our final rule.
Were you thinking we were going to be June 27th?
No, we had it down initially as June 20th. I was thinking about moving it to the following week. That way there, I could work with Rob and also with Allison to incorporate changes that I think would be advisable to the board Then come back on the 27th to finalize, if you will,
27th June.
June.
Yeah.
And that way there, just before she is out.
And then we have everything good to go for
Ready
all.
to go, correct.
And I'm
But
not
no
out the
meeting on
entire
June 20. I'm just saying. So hearing is on June,
16th.
and our next meeting is June 27th.
No, it's June 20th. I'd like to move to June 27th, the week that we.
I was just assuming that we were moving. I'm fine with June 27th.
I can't do it in the afternoon.
Morning's fine.
I'm gonna do 10
I
to
could
12,
meet in the morning.
June 27th
10 to 12.
and the 12th. Then at that point in time, we'll take the public comments and so forth. If I think there's something in there that really needs to be changed, I can work with
Right, then we'll have time
drafters
to
and
do it.
trying to do it.
That makes,
Makes sense, Jim?
And two, and that way, I would assume you guys would meet in July before we file on the 28th. Because OLS will not have their comments to us before we meet on the 27th.
So you're asking for a meeting in July?
Yes, because then we'll have to, whatever comments they have, we have to address, and the board would need approval to approve them before I file them.
So if I want to be sure I'm tracking here. We'll have the public meeting on the 16th. We'll close public comments on the 23rd, which will give us time to get revise the rules if we need to, for the board to review on the 27th, which is June 27th. The board signs off on those rules that go forward to JLCAR in July.
Yes, so the board will have to have a vote to approve the final proposal before filing.
On June 27th.
No, so that would be sometime in July. Probably right
Right.
before we file, so like towards the end of July.
but we don't want it. I'm confused. So the board approves after the public comment period. We have a meeting, we approve our version of rules and regs.
So we won't have comments from OLS back yet, so we'll have to incorporate their comments as well.
When will those be back?
It's a who knows? I can put a bug in their ear, but it would probably be sometime in
So
first
we,
weeks of July.
but don't we need to, do we need to wait and incorporate public comment before we send it to OLS?
Yes.
So, just to clarify, we, on the 27th of June, we will incorporate public comments and send those rules and regs over to OLS for review. And then,
Oh, I know what you're saying. No.
no.
Okay, no. So OLS, these rules, OLS will receive. So after we get the fiscal impact statement, I filed this version with
Ah,
OLS.
Got it.
They
okay.
comment,
Was
I
the only one who
apologize.
wondered about
They
that?
comment on this version
Okay,
that we file with them that we're approving today with the. final
So
revision.
we just need a meeting to incorporate public comment and OLS comment, and then we vote on it and it goes to jail card.
Yes, in July, yep.
okay.
So you could even not have the 27th meeting and
That's
move
what I was
it
getting
to
at.
like the. I mean, if it's,
All right, so we want to have the meeting in July, toward the end of July, to look at all the feedback and come up with our final version.
yes, so
Yeah,
we'll need to file by July 28th. And that is actually the week I'm back in the office. And
okay,
the good thing about boards, I can bring the cover letter down here with me during the meeting and have it signed. And after that meeting, we can,
So why don't we meet on the 25th?
of July.
And
That makes sense. Can we do July?
everybody available?
Who knows?
Who knows? I don't even know
I
if I'm
can't plan
available,
that
but I
far
think
in
we should.
advance.
So we're moving the 27th to the
July.
July 25th.
25th.
Oh, so there's no meeting on June
We
27th.
don't need to,
We won't have everything back.
Yeah. but I'll have a time to sitting with. Comments will come back from all us,
yep,
public comments, and I can work with you folks on the final draft rules.
yes,
And on the 20th, 5th of July, the board can finalize that last set of rules and then it goes on the gel card.
That's correct.
Perfect.
So we can skip the one in June.
Clear as mud. All right, I got it. July 25th, 10 to 12.
10 to 12. So. Okay, now, I have some good news.
Did we pass?
I don't know, not yet. I gotta figure out what's going on. Wait for Bill. We know that we had a resignation from the board. I spoke to Professor Soloway, Representative Soloway, and he said there's a gentleman named Robert Woodward, who is a professor who's retired, who actually does a lot with drug pricing. And he's willing to be on the board to replace
This is
Stacy.
who was Stacy's appointer?
That was the
Todd
speaker,
was the
Speaker.
governor.
speaker. So I need to reach out to
Sure.
Sherman and talk to him about. It's a great candidate to have somebody who's got that expertise and so forth, to be a tremendous asset to the board. So he works a lot with farm and so other companies, so forth, and how they set drug pricing. They could addition to us.
So he's not a consultant.
No, as far as I know, he's retired. I asked about that specifically. I got the clearance from Senator Soloway. He was fully retired.
Senator Salvo.
That's right, Joseph Soloway.
Professor Soloway.
Soloway. And also next month on May 23rd, it gets confirmation from Heidi Pearl. The insurance industry will be here to do a presentation to us as well. And I'll hopefully have some members with the board to look at as far as looking at claims data and looking at the average cost per claim, looking at increases, if you will. So I'm working over that with him. I hope to have some information. He could be here to present it to us,
And that's 10 to 12.
10 to 12.
What's the date on that meeting?
May 23rd.
That should be interesting. Move to adjourn.
All set?
Aye.
Very good job. Aye. Very good.
Thank you. Yeah, I have to. Lots of-
I want to say this, I do have the pleasure occasionally to chat with some of the other folks. There is a
Public comment, sorry.
public comments.
I
Point, thank you.
take back my motion.
I take back my second.
Okay, back in motion. Sure. Public comments? Anyone out there in the public that wants to comment?
Do you have
Do we have any participants left? Is it adjourned? They all left.
Do you want to say anything?
You're good?
Move to adjourn. Aye.
But one of the things I'll say is that there is a group of individuals in different chairs of different boards throughout the country. And I'll say this to you publicly as well as privately. We are far ahead of some of the other boards. We've done a lot as far as what we have accomplished. And it's nice to be able to be out in front leading, and helping them understand what we're doing here. So it's been a privilege to be part of it.
And hoping House ED&A allows us to continue.
Yes.
And fiscal.
This one. What's it gonna
And
be?
jail card.
Does that? Gel card. Yeah, that's
Jail card. I thought fiscal had something on the table.
fiscal is about to question the rules. We tabled it.
Just goes about accepting the money to hire an executive director.
All right.
All right. Thanks, everybody.
Great work. Thank you.